Children often treat their parents like an ATM machine. They use the court and the Substitute Decisions Act as a platform to throw darts against one another. We deal with this all the time, and hence the inspiration for this seminar, which is a power of attorney disputes. There are 4 topics that we're going to be covering today. The first is validity of gifts to attorneys for property, while the donor or grantor is of questionable capacity. The second is power of attorney and accounting. The third is the grounds for removal of an attorney for property or an estate trustee, and the estate trustee during litigation. And finally, the 4th panel, romance and the elderly. Now, our format this year is going to be substantially different. What we're going to do is we're going to use a model of a family meeting, a pre-mediation. That's when families get together before they hire the lawyers, and they try to hammer out their disputes with a mediator. We will have 4 of these vignettes. After each vignette, which is going to be taking up here, there will be a panel discussion at the other end of the room where you'll have first-tier experts in the area discuss the issues that were raised in the vignette. In case you're concerned that you're not going to be able to see, because of your location in the room, either the vignette or the panel discussion, you'll be able to see it by the Jumbotron to my right. Please take a minute to go through your binders. On the inside of your binder, you'll see a little flash drive. This has all the papers that people work very hard on to prepare for today, in case you like things or store them in the electronic format. In your binder as well, you'll see there's a title page, and there's a letter to the attendees, which sets out the fictional scenario in our case study today. And just let's set it out in a very summary fashion. Mel and Selma have aged. Their daughter, Emily, moved in to care for them. Emily was appointed as the attorney for property and personal care, and she and her brother, Saul, are appointed as executors to both their parents' wills. Mel and Selma have developed dementia. Under Emily's tenure as an attorney for property, a whole bunch of money has gone missing. Selma, the mom, has also, after her husband passed away, she's developed a romance with a neighbor who's much younger, someone who she's traditionally hated. And she is giving him lots of money and enjoying a romance and a level of intimacy that gives one of her children cause for concern. Following the letter, you'll see there's a certificate of attendance for CPD hours, and following the certificate is the schedule for this morning. Now, there aren't going to be long introductions to people today. The profiles of the speakers and presenters are in your binders, but I'm just going to start off the event by giving an introduction to Jordan Atin. Jordan, can you just stand up for a sec? Jordan is an adjunct prof at Osgood Hall Law School. He's a lead instructor at Wills and Estates education called IWE, and he's also a firm counsel to Hull & Hull LLP. So we're going to give our technicians a few minutes to have the sound system in order, and then we'll start. Thank you.
Vignette 1. Validity of gifts to powers of attorney while the donor/grantor is of questionable capacity.
Just wanted to introduce my co-parties here. So to my left, Felice Kirsh, partner at Schnur Kirsh Olbaum Tater, practicing exclusively in the area of estate trust litigation, mental incompetency. She acts as a mediator, and she's a certified specialist in estates and trusts. And to my right, Greg Vander, partner at Torque and Mains, also a practice exclusively in estates and trust capacity litigation, and was the former chair of the OBA Trust and Estates section. So we'll begin. So this is our pre-mediation. So Emily and Saul, thank you so much for coming today. Let me tell you a little bit.
When is she going to pay back the money?
Well, that's good. What we're going to do today is we're going to be courteous to one another at all times, because the idea here is we're going to try to resolve this before you get those crazy lawyers involved. And the idea of one of these, have you guys ever been to one of these?
Are the police going to be here to get the money?
I haven't called them yet, but if things go badly, that'll be my next call. So the idea is that everything, it's only the three of us here. No one else is going to know anything about today's meeting. And everything that we say is confidential. You can't say, oh, but Emily told me that she stole the money. Or you can't say, Saul said it was okay that I have the money. Everything that we do today is confidential. Okay? So it seems to me, looking at the information that I have, that there's really four issues, right? There's the money that was given to Emily, or taken by Emily in your case. There's the issue of the accounting that Emily may have to provide as an attorney for property for your mom and dad, and the idea about who's going to go forward as the attorney for property and the executor of your dad's estate, and then lastly, the relationship between your mom and Pete, right? So we're going to deal with the first one first. And what I'm going to do is I'm going to break into a separate room with each of you, try to get an idea of what's going on in your mind, okay? So I'm going to start with you, Emily. You can just relax, Saul, thanks. So Emily, it's just you and me, so you can tell me anything that you need to tell me, and I won't go back to Saul and tell him anything, okay? Tell me a little bit about you and your mom.
Well, I have been living with my mom for my whole life. I was going to have a career, but I just couldn't, because someone had to take care of our parents. And I don't know where Saul was, but I don't know. He's taken a lot of trips. He seems to have a lot of nice cars. He has a couple houses and a cottage. Who was taking care of mom and dad all these years? It was me. If not for me, I don't know what would have happened to them. So I did everything. And you know what? If I had to pay myself a little bit here and there, it was well worth it, because I took care of my parents. And really, that's what this is about. Now, I don't really want to talk about anything else. That's what I want to talk about.
Okay, so that's helpful for me to know about your relationship. Tell me, your mom, she started to get worse as time went on. When do you think that started, like as far as you know?
Well, Mr. Mediator, I don't know if you have parents or not, but all parents start to get worse. At 80, at 82, at 79, I don't know. I don't know when it started. I can't tell. I'm not a doctor. I was busy. I was helping them. I was taking them to medical appointments. How do I know when it started? At some point, yeah, they were a little forgetful. Some days were good, some days were bad, but I don't think they were more forgetful than anybody else at that age.
Right. And how did it, I know that there were some gifts given to you over time. How did those come to be? Did you ask for those? How did it happen?
Well, my parents really appreciated what I did. They knew there was no Saul. Saul was nowhere to be found. So sometimes they said, Emily, take some money. You've been a good daughter. Take some money. And, sometimes I didn't, but sometimes I did, and I deserved it.
And tell me a little bit about Saul and your relationship. How did you guys get along?
Saul and I, really, we hadn't gotten along since grade 5.
Right.
I was in grade 5, he was in grade 3, and things haven't been good.
Right.
He always thought he was better than me. He always thought he could boss me around. He always told me what to do. He went to university and I didn't. So, you know what? Things haven't been good for years and years and years. It's a bit sad because he has a daughter and I hardly know her, but that's what he wanted.
Well, that's great. I'm going to go now into Saul's room for a second. That's really helpful. And we're gonna be back and forth. That's my job. I sort of run back and forth, okay? So, hi Saul, how are you doing?
Hi, Jordan. Sorry we got off to a bit of a rocky start there. I just, I don't know what she's talking about in terms of why she won't give the money back.
Tell me a little bit about your mom and your dad. What was your mom like, for example?
My mom,
or is like?
She's a lovely woman. You know, very caring. Both my mom and dad tried to inspire both my sister and I to go on, be independent, be educated. You know, try to lead our own lives. Only one of us took it to heart, and throughout the whole life of my sister, it started back in grade 5. You know, you know, she needed money, and Dad's wallet was there, and she took the money. And ever since, I got blamed for it, and because I was the oldest one, and she didn't come forward and say that she took the money. So ever since then, we've always had this rift. But it showed what kind of person she is by taking the money. And I don't know what she's told you about, you know, what she's done. And I hate to say this. It's not nice to say this about your sister, but she's a loser. And she never tried to get a job, or if my dad tried to help her get a job, she wouldn't show up. She's always in the casino. I don't know, it was in my mediation brief that she goes 6 days a week to the casino, and I've even got an investigator's report that shows that there are transactions across the street from that.
Right, okay, but let me just go back for a second. What about her relationship with your mom? Now, I understand that she lived with your parents, right?
My parents are taking my parents until 2012, about 5 years ago when they started getting their dementia. They were looking after her. The records are there. They show that she's at the casino 6 days a week. How can she be looking after my parents if she's at the casino? And I bet she hasn't told you. It's in my brief. It's not in her brief. She took $2 million. Right. $2 million.
But what do you say about the care that she provided for your parents? I mean, in fairness, right? Saul, like, you weren't there all the time, right?
Oh, I called.
Right. No, and I'm sure you did. I'm sure you did. But you weren't there all the time.
I'm raising the only grandchild of my parents.
Right. I understand that.
I'm busy with that.
But certainly your parents, I mean, you admit that your parents were getting worse.
My parents were getting, no, there's no doubt, my parents were getting really bad. In fact, when she took $1 million or $500,000, my parents couldn't even remember our names at that point. They didn't even know what bank account the money was coming from. And she took $500,000 at that point in time. Then a couple years ago, at my daughter's bar mitzvah, they gave me a check for $100,000. I knew they couldn't understand what was going on. I gave it back to them. She knows I gave it back to them.
Right.
They didn't know what was going on. They couldn't remember my name. They sure as heck couldn't remember her name.
Right.
Except if they looked at their bank account, they would see her name notionally beside every transaction, taking money out.
And as far as the care that was provided for your parents, what would you say about that?
Care was fine.
Yeah.
Care was fine.
So, I mean, that's an important point. Wouldn't you agree with me?
It is a point.
Okay.
It is a point.
But we're really here, right? We're here about your mom, right? That's what we're here about.
I love my mom, and I want my mom to see my daughter all the time.
Right.
But it doesn't seem right that my sister cannot work and has taken $2 million plus the condo in Florida, and she's not prepared to pay it back.
Right.
It's my mom's money.
Okay. So that's great. Let me turn this over for a second. I'm going to go back, and we'll be back. Okay.
You.
So. Just to let you know, I was just in the room with Saul, and so I'm just getting a feel for what's going on here. As far as
Did he tell you he's never around?
Well, I learned a lot of stuff in that room, and I learned a lot of stuff in your room, and I'm trying to put together a little bit of the puzzle, right? So, but we're making progress. We're learning some stuff. So, tell me about the money that was gifted to you. What are you spending that on?
Do I have to tell you?
Well, again, it's confidential. It helps me understand how we're going to try to resolve this.
Well, you know, I need to have some money put away for when my parents pass away because, you know, I don't have a career. How am I going to live after my parents pass away? I've lived with them. I've taken care of them all these years. My brother has been nowhere to be found. Ask him, did he take them to one medical appointment?
Right.
Did he take them to shul? Did he take them anywhere? He's going to say no. So I have to save a little bit of money for when my parents aren't here because He's got tons of money and I don't have anything.
Okay, so just so I know, and it's kind of important for me to know, is the money still there that was taken from your mom's account, that was gifted? Is it still available? It hasn't been spent yet?
Some of it's available.
Okay, that's great. So there is some money, and is it in your name?
Yes. Yes, it is.
Okay. Remember, everything you tell me is confidential, so you don't have to worry. Okay, I'm trying to get a feel for this. We're here to try to resolve the dispute, right? So the more I know, the better it is. So that's great. So I'll be back to you, okay? Hi, Saul. How you doing?
Hi, Jordan.
I know it's a long day.
Do you still have your wallet, or did you take that?
I always put my wallet away in a safe place whenever I'm mediating. Yes.
Smart mediator.
Yeah. So I was just in Emily's room and just getting a feel for what's going on, as you know, and I'm just trying to find out some things. So as far as you're concerned, does your mom need that money that went to Emily right now for her care, or how's your mom doing as far as finances go?
Well, my mom still has, by what I can determine, my mom still has about $1 million, and then there's a life insurance policy that has $500,000. And then there's the family house. But you never know what's going to happen. And the fact of the matter is, the will says that my sister's supposed to get the condo. She's already taken that. I'm supposed to get the family home, and then and then my daughter gets $150,000,
right,
and then we share the rest.
Right.
So I don't understand why she's taking this money as an early inheritance.
Right.
My mom needs the money. It's my mom's legal money. Like, I don't even understand why we're having this conversation.
Right.
It's my mom's money. It's not hers.
Okay. So thanks. I'm going to just be back to you in a few minutes, okay? And so I'm just going to be back to you in a few minutes, all right? So I am now going to turn it over to our panel to discuss the whole issue of these inter vivos gifts, alleged gifts, to where an attorney is involved. Emily was the attorney for property, and she is alleging that these were gifts to her. And so I'm going to turn it over to the panel to talk about that. The chair of the panel, of the first panel, is Ian Hull, who I'm sure all of you know. Ian's a co-author and author of several well-known texts, including Probate Practice, member of the CBA and the Certified Specialist in Civil Litigation and in Estates and Trusts. And I'm going to turn it over to him and his panel to deal with this issue.
Thanks very much, Jordy and the panel. That was an excellent vignette and a nice starting point for our panel. I just want to introduce the panelists at this time. We'll start to my immediate right is Clare Burns, a partner at Weirfoulds. Clare is well known to all of us who practice in this area, and is going to provide us with an excellent review of some of the law and analysis surrounding the issues of retrospective opinions. Carrying on with that is Greg Sidlofsky from the firm of Wagner Sidlofsky, a partner at Wagner Sidlofsky, and Greg has included in the binder an excellent paper regarding gifting. And then finally on the far right is Dr. Nathan Herrmann. And Dr. Herrmann is at Sunnybrook, and well known to us in the area who have dealt with him. He has provided opinions over time on retrospective opinions and opinions on capacity, and is an internationally renowned expert in this area of brain sciences. So, without further ado, we are going to talk through some of the potential issues that may have arisen out of the vignette and work through some of those from our perspective. So, we're going to try to have each speaker just do 2 or 3 minute introduction and walk through some of the topic areas that their papers have described, and then we're going to come back and pull in some of the facts that we were dealing with in the vignette. In particular, I'm looking forward to some findings of fact about the sister being a loser and the casino time. So I'm going to pass the microphone over to Clare Burns to begin with some introductory remarks, and then we'll wind this through with some panel discussion. Oh, you got a microphone. Good.
Yeah. So good morning, everybody. My brief, as assigned by Charles, was to do a takedown of retrospective capacity assessments. So it's the first time in my career I had to put a disclaimer on a paper because I don't want this cited back at me in the Court of Appeal by everybody. But the thesis of our paper is this, that generally speaking, retrospective capacity assessments, which are assessments where the doctor did not interview the person whose capacity is an issue, in our fact situation, that would be the deceased, during their lifetime. And so they're giving an assessment in respect of someone they've never met. And it's our contention in our paper that those assessments, generally speaking, are not admissible at law. They're opinion evidence. And our two principal arguments are these. For an expert opinion to be admissible, it has to be necessary to assist the trier of fact, to understand something outside the experience of the judge or the jury. And it's our contention that there is no necessity, because these retrospective capacity assessments, generally speaking, rely on the records of the treating physicians. Those treating physicians are in most circumstances available to give evidence and can give the best evidence about what their notes and their observations mean with respect to capacity. And with respect to lay witnesses, the people who will talk about the way the dearly departed was behaving, our two principal problems with that are that it's pretty clear that even judges can't reliably determine credibility of witnesses. We've got some interesting research in our paper that shows it's basically a flip of a coin as to whether or not they got it right. And we don't think psychiatrists are any better situated than judges to make that determination, particularly on a written record. And then the part that I know Dr. Herrmann likes the least, because he did laugh when I said this on our conference call, I think this is junk science. At the end of the day, there's no way to do a review of whether or not these capacity assessments are reliable or not, because the dearly departed is dearly departed. And I thought I'd make this point this morning by bringing a prop, but then I decided it would not be appropriate to bring a Ouija board into a synagogue. So that's sort of our argument.
Well, thanks, Claire. We'll come back to that and look forward to some interesting debate. Greg, if I could ask you to open your remarks and maybe just summarize some of the comments that are identified in your paper.
Well, thank you, Ian. I'm going to back it up a bit and talk about what is actually required for donative capacity. My partner, Brendan Donovan, and I submitted a paper titled, "Donative Capacity, the Law Taketh Away." And just as a brief overview, the paper covers the conditions that must be satisfied for a gift to be valid, the capacity required to make a gift, both contractual capacity and the more significant and more onerous testamentary capacity. And the paper also covers certain legal presumptions that often come into play in litigation concerning gifts, one being the presumption of resulting trust, and the second being the presumption of undue influence. Now, with respect to determining whether a transfer of property is a valid gift, there is a three-part test. There must be, one, an intention to make a gift without consideration or expectation of remuneration. Two, there has to be acceptance by the donee. And third, there has to be a sufficient act of delivery or transfer of the property. But then we get to the usually more difficult question, which is, did the donee have the capacity to make the gift? And the requisite legal capacity to make a gift is obviously one of the central topics today. And the test is dependent on whether the gift is of significant value in relation to the donor's other assets, or whether the gift is more trivial in nature. For substantial gifts, the test is generally that required for testamentary capacity. If the gift is more trivial in nature, then the test is contractual capacity, which requires the donor to simply understand the nature and effect of the relevant transaction. Now, getting to testamentary capacity, which is one of the central issues in many of the cases that we fight about. Most in the room are familiar with the decision in Banks and Goodfellow from the 1800s, and that's often cited for the test of testamentary capacity. But the more modern formulation requires the following to be proven. One, you have to understand the nature and effect of making a will. Two, you must recollect the nature and extent of your property. Three, you have to understand the extent of what you are giving under the will. Fourth, you have to remember the persons who might be expected to benefit under the will. Fifth, you have to understand the nature of the claims of people that you are excluding. And finally, the testator has to be free of any insane delusions that are affecting the dispositions in the will. And an insane delusion has been defined as A, a belief in an impossible thing, or B, a belief that in the circumstances no one in their senses could believe. As for the presumptions, I'll leave that to my paper, and if you'd like to get a primer on that, I would refer you to tab 5.
Thanks very much, Greg. We're getting a good legal backdrop to our upcoming discussion, and we can't have a good discussion without some medical observations. So we'll now turn to Dr. Nathan Herrmann to give us just a few opening remarks. Thank you.
Good morning, everybody. I guess you can hear me because I can hear myself echoing. I'm pretty conflicted at the moment because I know that there's a lot of people in the audience and even people on this panel that really want to see us have a knockdown, drag-out fight, Ms. Burns and I. And I think that may happen. We'll put on the gloves a little bit later. But rather than actually address my paper, which you can all read, and it is obviously supportive of retrospective capacity assessment, I thought what I might do is take you through how I do a retrospective capacity assessment for this particular case so that you have some insight into what this is really all about. So first of all, as a physician, the first thing I do is look for a diagnosis, and in this case I'm looking for a diagnosis of a neurodegenerative disorder that might be a threat to capacity. The next thing I would do would look for other neuropsychiatric disorders or neuropsychiatric symptoms or medical disorders or medications that might be concomitant or comorbid with this particular case to see if there are extra issues that might make the incapacity worse or might be a greater threat to the capacity. This is really very simply done by just simply looking at the medical records that come, that they're provided to me by the council. The next thing that I have to do, which is more challenging, is try to assess the degree of severity of the impairment. And this can be sometimes challenging because sometimes there really isn't a lot of information in the medical records, and we need to look at the affidavits to see how the person is described, to see if we can actually get a good idea about the nature of the severity of the particular impairment. After I've done that, I will actually try to apply the tests. And because I'm not a lawyer, I will rely on counsel to tell me what the tests are. And Mr. Sidlofsky just did that for me, and I would be able to try to apply these tests to the particular case that's in front of me. The next thing I would do is look for evidence of psychosis. Now, Mr. Sidlofsky mentioned the issue of delusions, and certainly that's something that I would be looking for. But for something like the tests for giving a gift, I would probably also be looking for something called a command hallucination. So a command hallucination is where the sufferer hears a voice telling them to do something. In most cases, this is to harm themselves or to harm other people. But command hallucinations can also be more benign. They can say, don't get out of bed today, don't go to work today, or please give all the money you have to Sher Shemaim B'nai Brith or the Kollel. And it is very difficult for people to ignore these command hallucinations, and they feel compelled to act on them. So I would be looking for something like that as well. And finally, I would be trying to look for evidence of undue influence. And actually, I'm not looking for evidence of undue influence. I'm looking for the medical condition, the neuropsychiatric condition, the neurodegenerative disorder, as well as medical issues or medications that makes the person susceptible to undue influence. I don't have an argument of whether undue influence took place or not, but whether they are susceptible to undue influence based on their particular medical issues.
Well, that's great. Thanks, Dr. Herrmann. All right, we want to now just bring our mind back to and test our memory for the vignette we just saw. And I was hoping that what we could do is we'll just go along the panel and look at their areas of expertise to comment on, in these facts, two issues: the questions of capacity and the usefulness in this situation possibly of a retrospective opinion. And I'll look to Clare and Dr. Herrmann on that front. And then, Greg, if you have any comments in regard to that, but also in regard to the question of gifting. I particularly draw your attention to Saul's admission that there was that he was never around, essentially, and that the care was fine, and those observations from him, and how, if anything, that may impact on your view as to whether or not a retrospective opinion might help in this case, both to defend the question of capacity and the question of gifting. So, Clare, do you mind starting that discussion?
So the fact situation is designed, I think, is quite interesting on the question of retrospective capacity assessments for two reasons. So obviously it would have to be retrospective with respect to the dad, to Mel, because he's dead. One of the things that I think is a problem in retrospective capacity assessments, and that Dr. Herrmann, who it really bothers me that he's so measured, eh? Like, it's quite annoying. But anyway, so the one of the things that Dr. Herrmann pointed out was that you have to look to the evidence of the lay witnesses. And here we've just heard in the vignette from Saul and from Emily. And Section 13 of the Evidence Act would say that neither of their evidence can be the controlling factor in deciding whether or not the gifts were valid. So it bothers me because I never see Section 13 referred to ever in a retrospective capacity assessment, and I think we need to start doing that. On Selma, I think it's more interesting because she's alive, but the gifts were made now some 5 years ago, and so you still need a retrospective capacity assessment. And when it gets to be Dr. Herrmann's turn, I would be interested to know what his thoughts are about how her current condition can be used in a retrospective capacity assessment, because I see a lot of what, from my perspective, looks like 20/20 hindsight when we have those sorts of retrospective assessments.
Greg, do you mind commenting?
We are dealing with hindsight, and that's usually what we're faced with. Some of the things that immediately jump out to me are the initial diagnosis of dementia was in early 2012. And from that date forward to 2017, there are $2 million in gifts that Emily was making to herself. So obviously the question that we're going to have to address is, was there capacity to make those gifts? And just the diagnosis of dementia isn't enough. There has to be an application of what her actual condition was at the time that she made the gifts, and some sort of analysis as to whether that satisfies the legal test. And often in early stages of dementia, you simply are not going to know from carrying on a casual conversation whether someone has the capacity to make a gift. And that's why the trier of fact, and why, as counsel, I would say we have to engage someone with the medical knowledge and experience to take a close look at what the person was actually experiencing and suffering from at the time, and then try to assess whether they have the capacity to do what they did.
Thanks very much, Greg. Now, Dr. Herrmann, you can be proud to know that it appears you've got inside of Clare's head. And We look to you now for some comments.
So I think that Ms. Burns and I actually agree on more than we disagree, and the first thing she said is the most important, that where there is no contemporaneous assessments of capacity, the retrospective capacity rules. In the land of the blind, the one eye is king. So I think that this would be a useful it would be useful for the litigation to have a retrospective capacity. And some of the things that I would do for this particular case, we heard about what role her current condition plays in terms of her illness. And we also heard from Mr. Sidlofsky that this is obviously a dementia that was diagnosed back in 2012. So he has 5 years of life in the lifetime of a patient with dementia. When I started my career 30 years ago, we would say the life of a person with dementia following diagnosis is 6 to 8 years on average. That's not the case anymore, and people with dementia can live 15 to 20 years after they've been diagnosed, and this has to do with the fact that we're diagnosing the illness earlier and we're treating these people in better ways so they live longer. So one of the things that I could do is, depending on the availability of the medical record, is graph her decline over the years and be able to give people an idea about how severe the dementia has been, what the trajectory of the decline has been, and when I would think at what point in time she might have been incapacitated in terms of making a gift, giving a gift based on the criteria that Mr. Sidlofsky mentions. I think this case also provides us with a lot of fertile material in terms of whether there was a psychotic element here, a delusion that might be involved in providing her daughter with the gift based on some of the information we're going to hear later in terms of her misidentifying the neighbor. And then finally, the fact that she was living with her daughter and was becoming more and more impaired, probably cognitively and functionally, would obviously make her highly susceptible to undue influence. So I think a retrospective capacity assessment could provide a lot of information for the courts to help explain what was going on.
Yeah, so go ahead, Clare.
So, Dr. Herrmann, on the question of doing a graph to effectively predict when she lost capacity, one of the things that worries me is whether or not there's actually been any longitudinal studies or any kind of data review to see whether or not that kind of predictive graphing relative to the legal test has been accurate. And do you know if there, I mean, I don't know the answer. Do you know if there's...
certainly hasn't. If you're asking if there's been specific correlations between the degree of impairment and the specific tests, whether it's, and let's talk about testamentary capacity, because that's obviously the one that's been most studied in the literature, and most studied means very poorly studied and very infrequently studied. But the answer is no. There is no direct correlation, to my knowledge, between, for example, a score on the mini mental state examination and when a person loses their capacity to make a will.
So one of the things that strikes me, and for those in the audience who are litigating this stuff or advising around it, is I'm thinking more that when I have these retrospective capacity assessments, I'm going to, if there's enough money in the case, hire an heir and a spare, as we say, as my experts. So perhaps hire Dr. Herrmann to be my expert then, but then hire one of the Drs. Schulman to give me my cross-examination questions relative to the medical literature, because when we looked at the medical literature in writing our paper, this is the problem, that a lot of this stuff has not been studied over time, and hopefully there will be studies in the future, but I think you've got a solid shot at taking this stuff out on the basis that there is not, in fact, a expert consensus about the science relative to the legal test.
But just like in the medical arena, where we have lots of good evidence-based treatment guidelines We would never blindly apply a treatment guideline to an individual patient because an individual patient is never representative of the average patient that we see that goes into the evidence that provides the evidence for the guideline. So we would always look at the individual patient. We would always look at their concomitant medical illnesses, the medications that they're on, their past history of treatment response before we would make a decision about treatment. And here we would do the same thing. Just because there is or there is not evidence that correlates the mini mental state examination with testamentary capacity, we would still have to use information based on that person's history and based on that person's presentation to opine on whether that person had testamentary capacity, regardless of their mini mental state score.
Yep.
I think that's excellent dialogue here. And I think just to add, I've also included a paper of the, I guess not the opposing, but I have included the literature and updated paper on retrospective opinions and the use of them. I've actually looked to the U.S. I've probably got cited over 25 articles on this area. I've worked with Ken Schulman over the years, and as well. There is a lot of literature out there, and it's something that's going to always be up in the air. But the last point I would say from a practical standpoint is these assessments tend to be a phenomenal settlement tool, which is hopefully the goal that most of us are shooting toward to try to resolve things because of the uncertainty and the cost of actually going to trial. All right, we're just about winding up here. We're actually moving back over to the next vignette, but I'm going to just ask each of the panelists to wind up with maybe some comments, and Dr. Herrmann, you mentioned it, this question of vulnerability and undue influence. In this vignette scenario, do you have any comments you might want to add in the context of how you manage the circumstances where vulnerability and undue influence are prevailing, as we've already observed, especially with the illustration of the vignette? Maybe, Claire, could you start?
So the trouble that I have with this susceptibility to undue influence business in the retrospective assessments is, in my view, it's just the doctors opining on whether or not there are suspicious circumstances. And I don't think that the doctors are doing anything other than reviewing the evidence of the lay witnesses, except in very limited circumstances where you have a very clear diagnosis, contemporaneous diagnosis about a neurodegenerative disorder or a command hallucination or something of that type.
Greg?
Well, it's difficult to prove actual undue influence, and that's why the experts generally limit their opinions to someone's susceptibility to it. We don't have a lot of information from these vignettes to actually allow us to give a fact-based opinion on whether there was undue influence. But that's the reality in most of the cases that we try.
Dr. Herrmann?
Yeah, totally agree with both previous comments. It's I think the responsibility of the medical expert to describe what factors are involved that increase the susceptibility or decrease the susceptibility to undue influence. So remember that people possibly with dependent personality disorders or depression or schizophrenia may make them more susceptible to undue influence. If you have a schizoid personality disorder, you will be less susceptible to undue influence. So there are factors that we can use from the medical history that might make the potential for undue influence more or less likely.
Well, thanks very much to our panelists, and thanks to everyone here. We're going to turn the program back over to the other end of the table, I believe. So back over to you, Jordy.